Good morning, everyone. I am Stana Buchowska and I am human rights and anti-trafficking activist working on, on trafficking issues for almost 20 years. Today, I would like to present an overview of the legal framework for child trafficking, and I would like to bring the most important milestones of international anti-trafficking legal efforts. I would like to start with the UN Convention on the Rights of the Child. Then I would a little bit talk about optional protocol to the CRC on the sale of children, child prostitution and child pornography. Then I would briefly mention Palermo Protocol and ILO Convention number 182 on the worst forms of child labor. Then we will proceed to UNICEF guidelines on the protection of child victims of trafficking and Council of Europe Convention on Action Against Trafficking in Human Beings, known also as a Warsaw Convention. And we will also explore Council of Europe Convention on the protection of children against sexual exploitation and sexual abuse, also known as a Lanzarote Convention. And I will start with the UN Convention of the Rights of the Child. The international community has agreed upon a number of legal instruments to prevent and respond to child trafficking. The most universally ratified international treaty to protect the rights of children is the Convention on the Rights of the Child, CRC, and, as it more specifically relates to child trafficking, the optional protocol to the CRC on the sale of children, child prostitution, and child pornography. Adopted by the UN General Assembly in 1989 and instituted as international law in 1990, the CRC is widely recognized as the first legally binding international instrument that incorporates the full range of human rights, civil, cultural, economic, political, and social, into a single text. The CRC was drafted with the specific purpose of promoting and protecting the well-being of all children, regardless of national boundaries. The CRC sets forth basic standards that individual nations agree to pursue on behalf of children. These norms rest on the CRC's four guiding principles: the child's right to survival and development to fullest potential, the child's right to be respected without discrimination in every aspect of life, the child's right to participate in family, cultural, and social life, the child's right for decisions to be made in his or her best interests. Emphasizing the primacy and importance of the role and authority of parents, the treaty calls for governments to respect their responsibilities, rights, and duties to provide direction and guidance to their children. In addition, the CRC calls on governments to develop and implement policies and programs that ensure children grow up in supportive family and community environments that foster an atmosphere of happiness, love, and understanding. As far as survival and development is concerned, survival and development is a principle by which the dignity of the child is recognized with consideration for children's special protection needs, to achieve their maximum potential, including special care by adults to help them live and grow. All decisions and actions taken to uphold and protect children's rights are made with the survival and development of the child at heart. Non-discrimination. Article 2 of the CRC reads, "State parties shall respect and ensure the rights set forth in the present convention to each child within their jurisdiction without discrimination of any kind, irrespective of the child's or his or her parents' or legal guardian's race, color, sex, language, religion, political or other opinion, national, ethnic, or social origin, property, disability, birth, or other status." In other words, every child within a state's jurisdiction holds all CRC rights without regard to citizenship, immigration status, or any other status. Refugee children, asylum seekers, and rejected asylum seekers are entitled to all rights of the CRC. Article 2 continues, "State parties shall take all appropriate measures to ensure that the child is protected against all forms of discrimination or punishment on the basis of the status, activities, expressed opinions or beliefs of a child's parents, legal guardians, or family members." Participation. Child participation is the informed and willing involvement of boys and girls in all matters affecting their lives. This includes children who are disabled and those at risk. Children have the right to be listened to in matters affecting their lives, with consideration for their evolving capacities and respect for their views. The best interest of child, according to Article 3 in the CRC, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration. The best interest of the child encompasses three main applications: government policy making, government decision, program design, programming decision, and decision made about children on an individual basis, individual decisions. The best interest of a child relates to our decision-making process with regard to children's rights, well-being, positive development, protection, and wishes. Policy decisions. The CRC requires states to analyze how each course of action may affect children. Because the interests of children are not always identical to adults' interests and can at times even conflict, the state must carefully separate out the various interests at stake. The government does not have to take the course of action that is best for children, but if any conflicts are identified, the state must make the best interests of children a primary consideration. This rule applies in budget allocations, in the making of laws, and in the administration of the government. Program decisions. Similar to how the government must create policies for the protection of all children in the state, organizations designing programs or making programming decisions on behalf of all children in a program location must do so considering how the rights, well-being, positive development, protection, and children's wishes will be affected on a broad scale. Therefore, rather than look at an individual child, organizations will assess a given population and design programs that will benefit this entire population. For example, an organization may design an awareness-raising campaign on the reintegration of children who have been trafficked. The program itself is not targeting any one child, but intends to bring awareness to support all children affected by trafficking. Participants should understand that the design of their activities can have an impact on an individual child or groups of children, depending on how the activity is planned and implemented. In addition, how they respond to child protection cases must be carefully thought through on the basis of the best interest of the child, with careful evaluation to ensure that decisions are not made solely in the interest of the parent, the agency responding, or sometimes even the child's own wishes. Individual decisions. When a decision is being made about an individual child, the child's best interests must be at a minimum a primary consideration. There are some situations where the child's welfare receives higher consideration. For example, in a case of abuse or neglect, a child can be separated from his or her parents if it is necessary for the best interests of the child, and this may be against the child's wishes. In an adoption case, the best interests of the child shall be the paramount consideration. In these cases, how a course of action might affect the child must be looked at closely, which is a requirement similar to that in policy decisions. The difference with individual cases is that under some CRC articles, a child's welfare must be given priority over an adult's. The CRC serves as the framework for governments to use in measuring their progress and challenges in upholding children's rights. Is it the essential legal document available for the prevention of child trafficking and protection of its victims? Article 35 of the CRC calls on states to take all appropriate national, bilateral, and multilateral measures to prevent the abduction of, the sale of, or traffic in children for any purpose or in any form. And Article 32 recognizes the child's right to be protected from economic exploitation. Per Article 39, state parties shall take all appropriate measures to promote physical and psychological recovery and social reintegration of a child victim of any form of neglect, exploitation, or abuse, torture, or any other form of cruel, inhuman, or degrading treatment or punishment, or armed conflicts. Such recovery and reintegration shall take place in an environment that fosters the health, self-respect, and dignity of the child. Optional protocol to the CRC on the sale of children, child prostitution, and child pornography. As an extension of the CRC to cover the increasing number of children exploited for sale, child prostitution, and child pornography, the optional protocol was put before the United Nations in 2000, together with the optional protocol on the involvement of children in armed conflict. The optional protocol defines exploitation and the sale of children as it relates to child trafficking, specifically in Articles 2 and 3, and calls on governments who have ratified the optional protocol to implement new policies and laws to counter the effects of child exploitation, set standards for prevention, and respond to abuses when they occur. Article 2. For the purposes of the present protocol, sale of children means any act or transaction whereby a child is transferred by any person or group of persons to another for remuneration or any other consideration. Child prostitution means the use of a child in sexual activities for remuneration or any other form of consideration. Child pornography means any representation by whatever means of a child engaged in real or simulated explicit sexual activities or any representation of the sexual parts of a child for primarily sexual purposes. Article 3. Each state party shall ensure that, as a minimum, the following acts and activities are fully covered under its criminal or penal law, whether such offences are committed domestically or transnationally or on an individual or organized basis. In the context of sale of children as defined in Article 2, offering, delivering, or accepting, by whatever means, a child for the purpose of sexual exploitation of the child, transfer of organs of the child for profit, engagement of the child in forced labor, improperly inducing consent as an intermediary for the adoption of a child in violation of applicable international legal instruments on adoption. Offering, obtaining, procuring, or providing a child for child prostitution as defined in Article 2. Producing, distributing, disseminating, importing, exporting, offering, selling, or possessing for the above purposes child pornography as defined in Article 2. State parties to the CRC and its optional protocol commit themselves to submit a report to the UN Committee on the Rights of the Child within 2 years of the protocol's entry into force, and subsequently every 5 years, to identify measures adopted applying the CRC and its protocol and to monitor the progress achieved. In 2004, the UN Commission on Human Rights established a special rapporteur on trafficking in persons, especially in women and children. The special rapporteur has the following mandate: takes action on violations committed against trafficked persons and on situations in which there has been a failure to protect their human rights, undertakes country visits in order to study the situation in situ and formulate recommendations to prevent and/or combat trafficking and protect the human rights of its victims in specific countries or regions, submits annual reports on the activities of the mandate. Another important legal instrument is the Palermo Protocol. As stated earlier, the Palermo Protocol sets out the first internationally agreed upon definition for trafficking, including the trafficking of children. It is the first international treaty that indicates that all aspects of trafficking should be criminalized. It focuses on prevention, criminalizing offenses, and protecting those who are trafficked. Another important legal instrument is ILO Convention number 182 on the worst forms of child labor. In 1999, the International Labour Conference adopted Convention number 182 on the prohibition and immediate action for the elimination of the worst forms of child labor, which came into force in 2000. The convention places child trafficking in the broader context of child labor. Article 3 recognized child trafficking as one of the worst forms of child labor. All forms of slavery or practices similar to slavery, such as the sale and trafficking in children, debt bondage, and serfdom, and forced or compulsory labor, including forced or compulsory recruitment of children for use in armed conflict, and calls for action by member states to eliminate them. UNICEF also became active in the field of protection of child victims of trafficking, and they submitted the guidelines. The UNICEF guidelines set out standards for good practice with respect to protection of and assistance to trafficked children. The guidelines are based on international human rights instruments and look at the protection of trafficked children from their identification through their recovery and integration. They should be used together with other guidelines and tools, focusing on prevention and response to child trafficking. Now, I would like to move to the European and European Union legal instruments. And I would like to start with the so-called Warsaw Convention, that is a Council of Europe Convention on Action Against Human Trafficking. The Council of Europe Convention on Action Against Human Trafficking came into force on 1st February 2008. The convention sets out measures to protect and promote the rights of victims of trafficking, which states are obliged to implement, including standards in relation to identifying victims, providing assistance, putting in place a recovery and reflection period, residence permits, compensation and legal redress, and ensuring any return to the home country is safe and dignified. More relevant in terms of the child protection and child trafficking is Council of Europe Convention on the Protection of Children against Sexual Exploitation and Sexual Abuse. It is also known as Lanzarote Convention. The Council of Europe Convention on Protection of Children against Sexual Exploitation and Sexual Abuse requires criminalization of all kinds of sexual offenses against children. It sets out that states in Europe and beyond shall adopt specific legislation and take measures to prevent sexual violence, to protect child victims, and to prosecute perpetrators. In the context of this convention, so-called Lanzarote Committee has been established, and it is the committee of the parties to the convention, and this body was established to monitor whether parties effectively implement the Lanzarote Convention. The monitoring procedure is divided by rounds, each round concerning a theme, starting with sexual abuse in the circle of trust. In order to assess parties' implementation of the Lanzarote Convention, 2 questionnaires are currently available. The deadline for submitting responses of these questionnaires is 31st January 2014. And now I would like to move to the European Union Directive on preventing and combating trafficking in human beings and protecting its victims. What is an EU directive? EU directives lay down certain end results and must be achieved in every member state. National authorities have to adapt their laws to meet these goals, but are free to decide how to do so. Directives may concern one or more member states, or all of them. Each directive specifies the date by which the national laws must be adopted, giving national authorities the room for maneuver within the deadlines necessary to take account of differing national situations and conditions. Directives are used to bring different national laws into line with each other. I would like to come back to the development process of the European Union law to offer some explanation of the way how we came into the directive. Until April 2011, European Union anti-trafficking law was made up of 3 instruments. The first one was Council Directive 2004 on the residence permit issued to the third country nationals who are victims of trafficking who cooperate with competent authorities. The second document was Council Framework Decision on Combating Trafficking in Human Beings from 2002. And the third was Council Framework Decision from 2001 on the standing of victims in criminal proceedings. These 3 instruments lacked the application, enforcement, and comprehensive approach necessary to prevent trafficking and protect victims. With the entry into force of the Treaty of Lisbon in December 2009, Article 34 of the Treaty on the European Union was repealed, and framework decision can no longer be adopted. Any legislation must now be adopted in the form of either directives or regulations. Therefore, the European Union took steps towards codifying its trafficking law into a binding directive, Directive 2011, which incorporates and replaces framework decision from 2002. Its main element, or what is the Directive 2011? The EU Directive on Preventing and Combating Trafficking in Human Beings and Protecting its victims sets out minimum standards to be applied throughout the European Union in preventing and combating trafficking in human beings and protecting victims. Its main elements are a revised definition of offenses involving trafficking in human beings, which is slightly broader than the contained in the 2005 Council of Europe Convention. Another element is increased criminal penalties for trafficking offenses based on a minimum term of imprisonment of not less than 5 years, and where there are aggravating circumstances, for example, the victim is a child, 10 years. A requirement for member states to enable competent national law enforcement authorities to seize and confiscate items used for the commission of and proceeds derived from human trafficking offenses. A non-prosecution and non-punishment provision, which requires member states, in accordance with the basic principles of their legal systems, to ensure that their competent national law enforcement authorities have a right not to proceed with a prosecution or impose a penalty in the case of victims of trafficking who have been compelled to take part in criminal activities. A requirement for each member state to establish jurisdiction for trafficking offenses committed by one of its nationals, even if committed abroad, and the conduct in question would not be considered a criminal offense in the place of commission. Detailed provisions on assistance and support for victims of human trafficking, which incorporate and, in some cases, exceed the standards established in the 2005 Council of Europe Convention. Specific and detailed provisions on assistance and support for child victims, which include, in certain circumstances, a requirement for member states to appoint a guardian or representative responsible for the child's welfare. A special protection measures for child victims involved in a criminal investigation or criminal proceedings. A requirement for member states to ensure that victims of trafficking have access to existing criminal compensation schemes for victims of violent crime. Provisions also requiring member states to take appropriate measures to discourage and reduce the demand that fosters all forms of exploitation related to trafficking in human beings, to raise public awareness of trafficking, to promote regular training to help police and other officials to identify and deal with victims of trafficking, and to consider criminalizing the use of services which are the objects of exploitation, with the knowledge that the person is a victim of a trafficking offense. A requirement for member states to appoint national rapporteurs or establish equivalent mechanisms to collect statistical data on trafficking in human beings and monitor and assess trends, and the establishment of an European Union anti-trafficking coordinator to collect data gathered by national rapporteurs, contribute to the annual report on progress made across the European Union in combating trafficking in human beings, and to coordinate the EU anti-trafficking strategy. The deadline for transposition of the directive of many European countries was April 2013. As we all know, only several European Union countries uh, stick with these deadlines. I hope that this overview of the European anti-trafficking legal instruments will help you to go through other presentations in this conference. I would like to thank you for your attention, and if you have any further questions or comments, please do not hesitate to contact me. Thank you very much.